stop. Before you get excited about this news, before you submit a single form, before you even reach out to your attorney, you need to hear what I am about to share with you. The April 2026 Visa Bulletin has just been released, and for the first time in years, the filing doors have opened wider than many of us expected. 4 groups of immigrants are now in a position to file for their green cards right now. Employment-based categories are current. Family-based categories are current. Certain asylum holds are being lifted. EB-5 investor categories are open for every country on the planet. Immigration attorneys across the country are advising their clients to file immediately. File today. File before this window potentially closes. But here's what most of them are not discussing openly. There have been confirmed reports of ICE conducting enforcement actions inside USCIS field offices during green card interviews. Individuals have been taken into custody during what they believed were routine appointments, sometimes in the presence of their family members. A significant majority of those affected reportedly had no prior criminal record whatsoever. So the real question is not simply whether you are eligible to file. The question is whether you should file right now, and if you do, how you protect yourself and your family from what may be waiting when you walk through those doors. My name is Timothy. This is US Updates Hub, and this video may be one of the most critical ones we have ever produced. Please stay until the very end. I am going to provide you with the complete filing information for all 4 groups, and then I am going to walk you through a 5-step protection plan that could safeguard your family. Do not skip ahead. Every part of this discussion matters. Let me start with the positive developments because they are genuinely significant. The Department of State released the April 2026 Visa Bulletin, and USCIS confirmed on March 17, 2026, that for all employment-based preference categories, applicants should use the dates for filing chart. That is the more favorable chart. That is the chart that allows a greater number of people to move forward with their filings sooner. This represents a meaningful opportunity. Let me walk through it group by group. Group 1 covers employment-based categories, specifically EB1, EB2, and EB3. If you are from any country in the world other than China and India, all 3 of these categories are marked as current on the dates for filing chart. Current means there is no queue. You are eligible to submit your I-485 adjustment of status application right now, this month, without any priority date barrier standing in your way. If you are from China, the EB1 dates for filing cutoff is December 1st, 2023. EB2 is January 1st, 2022. EB3 is also January 1st, 2022. These dates have moved forward, which means a larger number of Chinese applicants are now eligible to file. If you are from India, the EB1 dates for filing cutoff is December 1st, 2023. EB2 has advanced to January 15th, 2015. EB3 also sits at January 15th, 2015. The EB2 India category saw notable forward movement this month. If your priority date falls before January 15th, 2015, you may be in a position to file now. This is the widest the employment-based filing window has been in years, and the underlying reason is worth understanding. According to analysis from immigration professionals, certain travel restrictions affecting nationals of specific countries have reduced visa issuance rates from those nations. When allocated visas go unused, they become available to applicants from other countries. The State Department referenced this dynamic in the April Visa Bulletin. So, this window exists in part because of a policy that has restricted one group of immigrants while inadvertently creating opportunity for another. That is the honest reality of the situation. Group 2 covers family-based F2A, which includes spouses and unmarried children under 21 of lawful permanent residents. This is arguably the most impactful development in this entire bulletin. The F2A category on the dates for filing chart is marked with a C for current, not just for one country, for every single country, including Mexico. Current means that any spouse or unmarried child under 21 of a green card holder is eligible to submit Form I-485 right now, regardless of when their petition was originally filed. Let me emphasize that point. If your husband or wife holds a green card and you have been waiting in line for your turn, this month that wait may be over for filing purposes. You may be able to file today. You can potentially obtain work authorization. You can potentially receive a travel document. This is a historic moment for family-based immigration. However, and I need you to understand this clearly, filing the I-485 means you will eventually be called for an in-person interview at a USCIS field office. And based on what has been reported in recent months, that is precisely where certain risks begin. I will explain this in detail shortly. Group 3 covers EB5 investors. All EB5 set-aside categories are showing as current for every country in the world. The rural, high unemployment, and infrastructure designations are all current. Even applicants from China, who typically face years of backlog in the unreserved EB5 category, may be able to file immediately under the rural or high unemployment set-aside categories. If you have invested in a qualifying EB5 project and you are physically present in the United States, you may be eligible to submit your I-485 now. Group 4 involves asylum seekers from countries that are not designated as high risk. On March 30th, 2026, USCIS announced a significant policy shift. They lifted the adjudicative hold for thoroughly screened asylum seekers from countries not classified as high risk. This was confirmed by a DHS spokesperson and covered by major news outlets on the same day. Since late 2025, USCIS had effectively paused movement on asylum applications through a series of policy memorandums. Virtually no asylum cases were receiving decisions. But now, if you are from a country that does not appear on the designated high-risk list, your asylum case may begin to move forward again. The countries where the hold reportedly remains in place include Afghanistan, Burkina Faso, Burma, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Iraq, Laos, Libya, Mali, Mauritania, Niger, North Korea, Somalia, South Sudan, Sudan, Syria, Venezuela, Yemen, Angola, Antigua and Barbuda, Benin, Burundi, Ivory Coast, Cuba, Dominica, Gabon, the Gambia, Guyana, Lebanon, Liberia, Nigeria, Sierra Leone, Tanzania, Togo, and Trinidad and Tobago. If your country of origin does not appear on this list, your asylum case should potentially begin progressing again. Contact your attorney immediately to check the current status of your case. Now, here is the part that most other sources are not addressing, and this is why I asked you to stay through the entire video. Filing your I-485 is the first step, but the second step is the interview. And in the current environment of 2026, the interview carries considerations that did not exist in previous years. Since November 12, 2025, there have been documented reports of ICE agents being stationed inside and near USCIS field offices. Individuals have been taken into custody during and immediately after marriage-based green card interviews. This was first widely documented in the San Diego area, where an immigration attorney reported a significant number of enforcement actions occurring in a single day. Similar incidents have since been reported in Los Angeles, San Bernardino, San Francisco, Salt Lake City, Cleveland, and other locations across the country. By March 2026, reporting from Mission Local, published on March 26, 2026, indicated that at least 539 individuals had been taken into custody at routine immigration appointments in the San Francisco area alone. And here is the detail that demands attention. Reporting indicates that approximately 69% of those affected had no criminal record of any kind. These were spouses of United States citizens who attended their scheduled interviews believing they were following the proper legal process. They completed every form. They paid every required fee. They brought every requested document. And they were taken into custody at what they expected to be a routine appointment. The rationale behind these actions, according to ICE, is that the agency considers itself authorized to take enforcement action against any individual who is physically present in the United States without what they determine to be valid immigration status, even if that person is actively engaged in a legal process that Congress designed to provide them with lawful status. If someone overstayed a tourist visa and subsequently married a United States citizen and filed for a green card, ICE may consider that individual subject to enforcement, despite the fact that immigration law provides a pathway for immediate relatives of United States citizens to adjust their status under certain provisions of the Immigration and Nationality Act. This practice has been challenged in federal court. A Maryland federal judge issued an order blocking the arrests. The Department of Justice appealed to the Fourth Circuit. Oral arguments were held on February 2, 2026. On March 26, 2026, reporting from NPR indicated that the DOJ acknowledged in court that erroneous information had been used in some cases to justify the enforcement actions. Despite this, DHS has indicated that the overall policy direction is not changing. On the same day the asylum hold was partially lifted, March 30, 2026, USCIS also announced what they described as strengthened screening and vetting procedures. Here is what that means in practical terms. USCIS stated that prior screening and vetting processes were, in their own words, inadequate. They indicated that applications had been approved and individuals had been naturalized who, in their assessment, should not have been. As a result, they are implementing additional layers of review that did not previously exist. The new vetting measures reportedly include shortened validity periods for employment authorization documents to require more frequent security checks, updated photograph policies to strengthen identity verification, expanded social media and financial vetting along with community-level interviews, automated notifications triggered by biometric matches and new criminal information, final review of arrest and encounter records before any case receives approval, and Department of State consular database checks before final adjudication. That last point is particularly significant. Before your green card application is approved, USCIS will now reportedly cross-reference the State Department's consular database. That database contains records of every visa application you have ever submitted, every consular interview you have attended, and every notation a consular officer has ever recorded about you. If there is any discrepancy between information you provided to a consulate years ago and what you included in your current A485 application, that inconsistency may be identified and flagged. Additionally, social media screening has reportedly become a standard part of the review process. USCIS is said to be reviewing applicants' activity across Facebook, Instagram, WhatsApp, Twitter, TikTok, and other platforms. They are reportedly looking for inconsistencies with the application, indicators of potential fraud, affiliations that may raise concerns, and any content that could be considered relevant to security screening. USCIS referenced the expansion of social media vetting in their March 30th official announcement. On April 1, 2026, a federal appeals court issued a ruling that halted a nationwide injunction that had been providing certain protections against expanded detention policies. The practical effect of that ruling is that the protection now only applies within the Central District of California. In every other jurisdiction in the United States, ICE reportedly has authority to detain individuals without bond under the expanded policy framework. What this means is that if you file your I-485 today and are eventually called for an interview in Texas, Florida, Georgia, New York, or any state outside the Central District of California, there is currently no nationwide court order protecting you if ICE decides to take enforcement action at that appointment. Now here is what you came for. If you belong to one of the four groups I described and you want to file, I am not suggesting that you should avoid filing. This is a legitimate opportunity. These filing dates could move backward next month. The window could narrow or close, but you need to approach this strategically. You need to file with full awareness and preparation. Here are 5 steps to consider. Step 1. Submit a FOIA request before or at the same time you file your I-485. Go to the DHS FOIA website and request your complete immigration file, known as your A file. This is the file containing every record the government has compiled on you, including every entry, every exit, every visa application, every encounter with CBP, and every notation from an immigration officer. You should review this file before USCIS reviews it at your interview. If there is an old removal order you may have forgotten about, a missed hearing from years ago, an identity discrepancy, or any other irregularity, you need to be aware of it now, not when you are sitting across from an adjudicating officer. This process takes time, often several weeks. Submit the FOIA request as soon as possible, ideally the same day you file your I-485. Step 2. Conduct a thorough audit of your social media presence right now. Review every platform you use: Facebook, Instagram, TikTok, Twitter, WhatsApp status updates, LinkedIn, and anything else. Identify and address anything that could be perceived as contradicting your immigration application. If you indicated that you were not employed but posted photos suggesting otherwise, take note. If you were present on a temporary visa but posted content suggesting an intent to remain permanently, take note. If you have posted content that could be interpreted as expressing support for any organization that the United States government considers a concern, take note. Do not delete your accounts entirely, as that may raise its own questions. But address any clear contradictions and exercise caution about posting anything related to your immigration case on social media going forward. Step 3. Retain an experienced immigration attorney before you file, not after. In the current environment, filing an I-485 without legal representation carries risks that are simply too significant. A seasoned immigration attorney will review your complete history, identify any potential issues that could trigger complications at your interview, and prepare you for the enhanced vetting procedures. Equally important, your attorney should be physically present with you at your green card interview. USCIS has reportedly reinstated mandatory in-person interviews for most cases. If any enforcement situation arises during your appointment, having your attorney present provides you with someone who can immediately advocate on your behalf, document any procedural concerns, and take emergency legal action within hours if necessary. Step 4. Prepare an emergency contact card. Every individual who walks into a USCIS office in the current climate should carry a card containing the following information: your attorney's name and direct phone number, the ICE detainee hotline number, the ICE online detainee locator website address, your A number, and one sentence committed to memory. I am exercising my right to remain silent, and I would like to speak with my attorney. If you are approached by enforcement agents, do not answer questions beyond identifying yourself. Do not sign any documents without your attorney present. Do not attempt to explain your case on the spot. State that one sentence calmly and clearly. Present the card. Remain composed and silent beyond that point. Your spouse, the United States citizen or permanent resident, should carry a separate copy of this card along with clear instructions on what steps to take if you are detained. Contact the attorney immediately. Check the detainee locator system. Document everything that occurs. Step 5. Understand the strategic timing of this situation. Here is the practical reality. You want to submit your I-485 now to secure your position under the current dates for filing chart before those dates potentially move backward in May. But your interview will not be scheduled for months. By the time you are called in for that appointment, the legal landscape may look different. The Fourth Circuit could issue its ruling on the Maryland case. The Supreme Court could weigh in. Legislative action is possible, so file now to preserve your place. But use the months between filing and your interview to prepare thoroughly. Obtain your FOIA file. Address your social media presence. Brief your attorney on every detail of your history. Assemble your complete evidence package. Practice your interview responses. And finalize your emergency plan. The applicants who will navigate 2026 most successfully are not necessarily the ones who file the fastest. They are the ones who file with the most thorough preparation. Let me provide you with a quick summary so you have everything in one place. Group 1 covers employment-based EB-1, EB-2, and EB-3. These are current for all countries except China and India on the dates for filing chart. China and India have specific cutoff dates that moved forward. File your I-485 now if your priority date falls before the listed date for your category. Group 2 covers family-based F2A, spouses and children of green card holders. This category is current for all countries with no priority date requirement. You may file your I-485 now. Group 3 covers EB-5 investors in the rural, high unemployment, and infrastructure set-aside categories. These are current for all countries. You may file now. Group 4 covers asylum seekers from countries not on the high-risk list. The processing hold was lifted on March 30th, 2026. Check with your attorney to determine whether your country is affected. For the protection plan, Step 1 is to submit your FOIA request. Step 2 is to audit your social media thoroughly. Step 3 is to hire an experienced attorney before filing. Step 4 is to prepare your emergency contact card. Step 5 is to file now, but invest the waiting period in comprehensive preparation. I understand that this discussion may have given you both hope and concern at the same time. That was the intention because, in the current environment, optimism without preparation can leave you vulnerable, and concern without action serves no purpose. The filing doors are open. That is a real and significant development. But the process behind those doors has changed. There are new screening measures, new vetting protocols, new enforcement presences, and new risks that simply did not exist a year ago. File if you are eligible, but file with full awareness. File with proper legal guidance. File with an attorney committed to standing beside you and a contingency plan ready in case you need it. Share this video with every immigrant you know who is waiting for a green card. Send it to your family group chat. Send it to your colleagues. Send it to your neighbors. One share could prevent a family from walking into an appointment without the preparation they need. Subscribe to US Updates Hub and turn on notifications. We are covering every immigration development in real time as it unfolds. And leave a comment below. Tell us what your immigration situation is. What category are you in? What concerns do you have? Your comment helps shape our upcoming content so that we can address the questions that matter most to this community. This is US Updates Hub. File smart, stay protected. This content is for educational and informational purposes only. It does not constitute legal advice.